Winnie Mengi is my name. I am the estate planner KE on all socials, but currently I am going to be your legal hat for the afternoon. Put your questions in the chat section, Q&A. I know I've been answering a few of them that Mnindo was also raising through her presentation, but we'll keep answering them and we'll have the live Q&A after we've gone through this. So exactly what is an unfair advantage? We've understood so many things about what an unfair advantage, and this is before I get into the legal speak of how are we running or creating an unfair advantage. If you've ever been in a position where your parents or even your grandparents have taken you through school, that already gives you an unfair advantage over many other people. But that not to say that it's the only advantage that you've gained, because now through education you've opened doors that allow you to see how you can gain as an adult or as a young adult. You can gain income, you can make an investment, you can gain relationships. So all those things are what we're talking about when we talk about legacy. So the unfair advantage is your legacy will not just die with you, it will continue to the people who you care about. And these do not only have to be your children, but I know I don't speak only for myself. Many of us think, I think I need to do this for my children. But what if you do not have children? You're still welcome to this conversation, because children or not children, you still have dependents. And I've seen one of those questions earlier, and I hope part of our conversation will answer some of the things. We will demystify trusts. We will demystify some of these legal documents that you've had talked about over and over and over again. What is a will? What are powers of attorneys? What am I supposed to do with them? How do I understand which one I need, which one I don't need? And it's very critical to put them in your mind as I can have all of them, okay? All these things are what we call establishing your protection measures. You can have it all. It just takes a little bit of planning. So in case you're a young adult, and allow me to say young adult being up to 35, but I know we can stretch it. We can actually minimize the age to 25. Young adults or early adulthood is considered 20 to 25, but 20 to 25, usually you find yourself navigating the hemisphere of education, tertiary education perhaps, or new business startups, or you're just beginning your entrepreneurial journey. So between 25 and 35 is where we call early adulthood in terms of financial planning. So what do you need to do? You're right. The person who commented last saying we need to first build the investment before we talk of giving it down to our generations. You need to have clear goals. You need to know that your money habits are correct, not just spending every single coin on pleasures of life, because life is, we're here to enjoy. Yeah, we're here to live a good life. But at the same time, we need to be prudent and wise in understanding that there are people who we take care of, and we also take care of our future selves. So if you love yourself and love the people that are around you, then you're in the conversation to understand how to pass on this love. So you've done your financial goal setting, and Coach Susan is here. She's helped you navigate all those investment paths, and now you have that plan. And you've established some good money habits. You've started saving, you've started budgeting, you've started clearly investing in things bit by bit, because everything is a brick by brick process. And then now you've also taken up maybe some form of insurance. You've put your retirement in order and protected that part of your age gap. And you've met someone maybe, or you're married to someone, or you're dating someone, and you're thinking, we are aligned in our values and we're aligned in our purpose. So how do I then create an advantage for ourselves? Yeah. The 4 key things that you need to have within your plan, because all these plans are centered around what we own, including our bodies. Okay. So what we own, how we clothe ourselves, to what we drive, where we live, what we're trying to buy, the people we're investing with, the shares we want to invest in, the income we're trying to gain, secondary, tertiary income, however you want to build it. You need to know 4 key things: that you've budgeted properly for it, including budgeting for advice around it, that you've clearly defined your beneficiaries, you know who depends on you in this lifetime. Unless you're truly, truly alone and you live on an island, every man has someone that depends on them. It could be your employee, it could be your parents' employee, it could be your child, it could be your spouse, your girlfriend, your boyfriend, anybody could truly be your beneficiary. Then you need to have a clear plan and instructions. And instructions start from your mind. Set an instruction plan for yourself. Then create the rainy day trust and insurance. Okay. So we have those 4 key features, and we're going to get into now the nitty-gritties of what we need to do. But before then, and I know Nindo has covered this as well, there are different types of families in this day and age. We have the nuclear family. If you went through the 844 system like me, you met probably Tom and Mary's parents, and you understood that in every family there was a brother and a sister, a mother and a father. And for me, I found that very odd because I did not have a sister. So I used to wonder, is it my family? That's strange. But I'd not conceptualized that I'm also part of the family. I'm a sister to someone. Yeah. So even then, the nuclear family does not necessarily have to look like mother, father, brother, sister. It does not have to look like that. It looks very different in today's age. There are people who have married and remarried. There are people who've lost their spouses and remarried. There are people who have adopted children from other families, adopted children also from other welfare organizations. We have the families that do not have children, but they have other beneficiaries. So there are a couple, they've chosen to not have children, but they could think to who they can give what it is that they're creating in their lifetime. We have single parent families, either because of divorce or death. And we also have grandparent, grandchild families where maybe there was an orphaned situation or abandoned grandchildren. The parent fled or decided to just not support their own parents in raising their children. So the different types of families create different scenarios and risks in what we call succession planning. The succession planning journey is not just a death. Death is the final stage. We're all working towards our death date. But before then, there are so many risks and challenges that could come that could also impact you should you not have died before you need to have created a plan. Maybe you've become incapacitated, or you're in a position you're not able to clearly articulate what you need to happen around yourself, around your children, around what you have built in terms of asset base. So potential challenges are third parties. And I'm not going to talk about your nuclear circumstance, not your spouse, not your boyfriend or girlfriend or your child. Third parties, maybe siblings, maybe in-laws, perhaps it could be a friend, a business partner, it could be someone who you owe money, it could even be a creditor, an institution. They can raise a potential challenge to the plan that you have. There are life changes, and they affect us quite often. Life changes that are very common include divorce and death, but there's also the life change of adding a child to your family, losing someone from your family, or just changing the circumstance around that person. Maybe you're a parent and you're trying to plan for your children, and then they get married and disown you. There are some circumstances that happen like that. You need to think about all the circumstances, and not just you, but you and a trusted advisor can think around all the circumstances that can affect your life. Then you need to know your key documentation, meaning personal information, title information. You need to think about that. The role that will be played by either the will or the trust that you create. What do you need it to do? What is your vision and objective for creating it? Do you have baby daddy, baby mama drama? Do you have those kind of people who do not necessarily depend on you, but can affect a dependent of yours? Do you have those people? Do you have a situation where you're currently single, you're presently married, or you could be single, yeah, potentially single in the future or in the imminent future? That means you're probably in a separation kind of situation and you're going through a divorce, you're potentially single, or you're planning to get married and you're trying to navigate the legal knickknacks around it. There are so many issues that affect us, and I'm going to cover them in 3 fronts. us being a single adults and being married adults, there are three key issues in terms of singlehood, where I've seen a situation where people are single, they don't want to plan because they're hoping to get married so that they can plan. But the marriage could actually affect the plan that you thought you wanted to have. So you need to be proactive even in your singlehood, because as we're told, you don't meet the right person, you become the right person so that you meet that person to be right with. Yeah. So you're not going to be right automatically by virtue of marriage. You start by being right today. So you need to be proactive about the things you're doing. Invest right. Budget right. Spend right. And even plan right. Lack of information also. I don't know whether it is because the media downplays a lot of succession battles, but information is really, it's lacking. Yeah, you get to find out things as and when you go. Now I'm in school, I need to do this. Whereas you can actually plan and say, my child is 4 years old now. By the time they're 13, I think their school fees is going to be about 200, 300,000 a semester at that time. Therefore, I need to make a plan to make sure I have 1 million shillings a year, every year for the next 3 years, 10 years from today. And that's a plan that you're creating. And the fear of the unknown. The fear of the unknown mostly around single adults, and not to belittle anyone, but the fear of not actually meeting your life partner. That is a very big fear that cripples plan making or initiating a plan. So if you're single and you're wondering, will I meet the right person for me? That question is not a question to be considered when you're creating a plan around the things that we own. And we will see what we own that really need us to think of them as valuables, not just gold and oil and, you know, 1 billion shillings. You actually do have some valuables. So you're seated on money and you need to understand how to plan around it. Then what do you consider when you're married? The common issues when you're married. I think marriage is one of the biggest life-changing factors in your life, but that's only because I am married. For some people, it is not, and it is a choice not to get married. But should you wish to get married, or you're currently married, it is very important to have a very common alignment between the two of you, because should any kind of mistrust come into play, that changes a lot of the direction that your plan or that your succession plan could take, even if you do not plan. So that I've seen in a recent survey, I think in 2023, that 83% of Kenyan couples think being in a relationship has had a positive impact on their financial positions. I don't know if it's because of joy, or, you know, you're no longer afraid of spending, or you're now free to discuss ideas with someone who's next to you all the time. I don't know whether, you know, those are factors that play into that, but that's a fantastic review. It's actually very welcome in this day and age where marriage has really been portrayed to be a waste of time. So it means that people who are opting into marriage are almost saying, I've become financially informed, I've become well informed, I've become financially secure just by virtue of getting married. But you can work on something for so long in your marriage, and I mean either a project that calls in a lot of your finances, and then you lose it by virtue of that marriage. Because you got married, you got an asset, and because you want to leave the marriage, you lose that asset. It's usually a very painful process, and it's almost like slicing your left hand off using your right hand. It's not easy. The emotions are not easy. Neither is the reality of the legal issues that need to be dissected. So the people who get into marriages should get into marriage first with a clear motive, not just an ulterior motive of marrying rich so that you can get the assets of this person, but that will make them understand, you know what, till death do us part, these are the things that I would like to see happening in my life. If we are not aligned in that, then it's best that we create a plan that separates us from the very beginning. Because Kenyans don't really play into prenuptial agreements, there are other options that you can take to make sure that you're giving yourself that unfair advantage. You're not just getting divorced and splitting things 50-50. You're actually getting divorced and advantageously, because you are allowed to invest for yourself in your marriage, and you don't have to lose it to a now estranged spouse. So your spouse also should, you subscribe to the fact that your marriage will end at the death of either one of you. Your spouse needs to know what kind of plan that is, who you're planning to enjoin as the people to execute your plan in your death, and whether they are comfortable with it. Are they okay with you saying that your mother or your father will play guardianship over your children? Is that someone that they personally trust, or they just seem to be cordial and happy with that person? And then when the time comes, they start saying, no, that one is very harsh with the children, or they won't look after them properly, because those are key factors in considering. And the third one is the key issues in the public arena. There are so many stories. I could start today and end tomorrow telling you stories, or I'll even end next week. But the one that really is highlighted a lot is the fact that a lot of the people who are wealthy or deemed to be wealthy in the public space end up in a very bitter succession battle. You find many renowned families don't even receive the property that was said to belong to their patriarch or their matriarch. They don't receive anything, actually. So all these things are stuck in court. They're stuck in between lawyers' offices, because no one seems to understand the plan that should have been there that was not there, or their entitlement has gone over and above what should actually have been. And that is because there are no plans. But there are ways you can navigate it. Yeah. So estate planning is it's like a part of the wheel of life. It's part of your financial tools. If you're budgeting, you should also be planning for your succession. If you're saving, you should be planning for who can receive it if you do not. Yeah. Who can receive it for you if you cannot also. If you love yourself enough to understand that you can be involved in a road accident today and nobody can access the funds to help you through your hospital treatment, and then you die because of that, because we all are aware of how healthcare can go. No hospital anywhere around the world will allow you to access their facilities if you cannot show them proof of how you will pay. So people will either raise funds or simply just, turn the other side and go away and hope for the best, or pray for you, basically. But if you plan properly, you can guide your finances into protecting you as well. So they'll protect you in your old age because you have a pension plan. They'll protect your family in case you die because you have a life insurance. And they'll also protect your assets because you have a plan and nobody will take them to court. So you have the powers of attorneys to think about. And we are seeing here a couple looking into, how are we supposed to do it? Should we do a power of attorney? Are we supposed to get a living will? What are those? What is a trust? How do I put it in place? Will this go into probate? And those are very good things to trigger a conversation between couples. I will start with wills, because wills cover two very important aspects in estate planning. They cover assets and they cover person. The person being the body that you're walking around in. The assets will be covered by the will that is written for your death. Okay, so you'll have either an oral will or a written will. And I beg you, please do not make an oral will. These are things that we should now be stating as things of the past, because they're almost called deathbed declarations. They can be set aside, and they are automatically set aside in law if you almost outlive yourself. Not almost. If you outlive yourself 3 months from the date you made that declaration, you need to make that declaration again. So to stop the confusion, it's best to have it written down. So you can write down a will to speak to who can benefit from what you own, and also to speak to your person. Okay. The will just has to have 3 things: two witnesses who are not gaining anything from your estate. They have no attachment to you other than the fact that they need to prove that you were there writing your will and they signed. Okay, those are the things that they need to do. You need to be clear and of sound mind. So you need to be above 18. And I trust that most of us are above 18. You also need to be of sound mind, meaning you are not under any influence, whether medication that is affecting your mind or other kind of illicit items that may be affecting your mental participation. You need to be very clear of mind that you're writing a will. And in your will, you can write about anything you own, from the ring on your finger, like Susan, or your hair, because people are even selling dreadlocks. You can write your will about anything under the sun that you believe is attached to your personal self. You can write your will, including your person, your body. Your body can be disposed of in different ways, okay? And here is a picture of a lot of people who come to me and they're writing a will and they think they are giving to many people. So they get so confused. They're like, what if I don't give my daughter because I believe she's married and I already gave her a house? What if I don't give my son? I already did this and that. What if I actually don't give my spouse? What happens to me? It should not complicate your living relationships. Writing a will should be very simple. Writing a will should actually be the simplest process that you can undertake. I want to show you a simple will, but in this, a sample will, sorry, but in this sample will, you'll notice a few things: that you must identify yourself, who your executors are, the guardians for your minors, and special needs dependents, because there are some people in this world that cannot survive without the person they're living with, and you can't just leave them alone. And you will feel tied to this life even if you get ill, because you have this person in your life. You feel like, oh, who will take care of them? And that conversation cannot be happening when you've passed away. This conversation needs to be happening when you're good, you're happy, you're healthy, but you are alive to the fact that you have dependents. And the last thing you will have in your will is a list of assets and how it is distributed. I'll show you the sample will at the end of this conversation, because it's a document, it's a live document that we work with that shows you how I'm going to put in what kind of words do I need to say? Do I just say I am Winnie Maingi, end of discussion? But if you Google today Winnie Maingi, you'll probably pull out 6 or 7 other people. So how do I identify who this Winnie Maingi is that is being discussed? How do I identify my executors? How will they be reached? How do I identify the guardians? How will they be reached? So those are the things that you need to answer as you're writing your will. And again, I implore you, please start writing your will today. Just start, set it down on a piece of paper, write down, my name is so and so. I own the following things. I have relationships with the following people. Who are these people to me? Simple questions that you can ask yourself, that maybe you talk to your therapist about, talk to your confidant about. It will amaze you the number of interesting questions that will come up just by saying, my relationship with this person is way beyond love and affection. My relationship is also financial because we are investing in a particular house with this person. Yeah. So you should be very honest with yourself, at least honest with your lawyer, and honest with your financial advisor, so that they can guide you properly into how to write your will. The second thing we're going to discuss is trusts. And trusts in Kenya have become a wildfire conversation. And I understand and I agree that it needs to be spread like the gospel. Trusts in other parts of the world are very well established, they're mature, and that's why we are not hearing of them and hearing of so many questions around trusts. They have matured them into the complex structures that they are today. But in Kenya, trusts, especially family trusts, became a conversation almost 4 years ago. They just started. And a 4-year-old, you cannot ask a 4-year-old what a 25-year-old knows. You have to take them pace by pace. A 4-year-old is more of a blank check. You can easily manipulate the situation around the trust. They are malleable. Before, the lawmakers also make it very rigid to create the trust. That is why trusts are spreading like wildfire, because they're so flexible, they're so easy to work with. You just need a fantastic legal helping hand to walk you through the trust journey. So what do you need to create a trust? A purpose, an asset, and a beneficiary. And I dare say that every single one of us on this webinar has one of those things. You have a reason. I have a child to take care of. I have an asset. I own a bank account. I own a house. I own a car. And then I have beneficiaries. I have a child. I have a parent. I have a spouse. I take care of them. Yeah. On the right-hand side, you'll see that a family trust can have 4 things. The settler, and that is just a legal term of the person creating the trust. So you, who is the one initiating the creation of the trust, called the settler automatically. Then the trustee is the person going to be given the reins of the trust. You have investment income, and I've seen that question. I have bought shares. Yeah, I have bought investments through my Dow CSD, CBK, and I own that account. I've bought bonds. I have bought, what kind of investment can you transfer? You've bought a house, you've bought a car. How do I help this investment go into the trust? Either through a will, by saying that, look, when I go, make sure you put this thing in a trust for so and so and so and so, or you create the trust yourself. It becomes a living trust. You create this trust, it comes alive with you. You make sure you have yourself, you've set up this trust. I own this asset. I'm the one who's naming the trustees. I'm the one who's going to create whether the trustee will be an individual, my friend, my sister, my brother, my mom, my dad. Anybody can be a trustee, or a corporate trustee. Corporate trustees must be registered. They must be persons who are offering these services professionally, and there are not so many in the market, but they are there and they're dealing with family trusts in the numbers. And you must have beneficiaries. A beneficiary can be anything, an individual or an organization. So we have trusts where people would like their property to go back to the government for, wildlife and environmental recreation. We have trusts that set up children welfare funds, probably for a children's home or for certain education grants for designate people or a designate group of people. You want to create a fund and you've invested so much, but you don't have a child. And you're saying, I want to make sure that the advancement of education in this country does not stop. Therefore, I'm putting trustees in charge of these funds to make sure anyone who wants to go study law in the University of X, to make sure that they can go through law school from 1st year to 4th year, and that person needs to be educated through my fund. You can do that. And it's possible as long as you have key individuals operating within your trust. In the law, because I'm a lawyer, allow me to rest on the law. In the law, we have created the person called the protector or the enforcer of a trust. Previously, we had the court, where if trustees show some form of incapability or improper behavior, they are taken to court immediately. But right now, the laws say, create an enforcer. Make that legal aspect in your trust. Put that, say, this is the person who will be the umpire. This is the person who will put the trustees in check. This is the person who will make sure that the trust is actually formed. This is the person who will make sure beneficiaries are not giving trustees a hard time by requesting frivolous things or trivial requests that they can pay for themselves. Make sure you have that in place, and then you can create a trust. Sorry. Sorry.
It's okay. We can give Winnie a second. Please let us know in the comment section how many of us are still with us. We've been so quiet in the comment section. Please confirm that you're still with us. We are still listening and benefiting from this particular conversation. Please let us know.
Thank you. You've seen those hands. Thank you for staying on with us, and we won't waste a lot of your time. Again, I said give me 30 minutes and I'm almost done. So let's continue. In the trust world, there are people called trustees. This is a part where we battle the most with people who create their trust. How are you choosing your trustees? Again, I said, my husband can be a trustee in my trust, but he's also a beneficiary. Who's going to say he will not choose to sell off everything that we own and put them in bonds because bonds are doing well in 2024, but in 2040, bonds are going to crash and my children will have absolutely nothing when now they're adults and they want a house to live in Nairobi. You see, there are questions that you need to ask when you're placing a trustee. You can trust the financial world today, and I'll give you a statistic. In 2003, the bond market 2003, 2004, the bond market really crashed. It almost went to 5-6% interest. Right now, bonds are doing amazing because we need to make sure that the country remains stable. We need revenue as a nation. We need to pay back the hefty loans that we've been granted with such high interest rate. And therefore, by the government offering you an opportunity to also stabilize its revenue base, it's important to understand why the bonds are so high interest at this time. But that's not to say that in 10, 15 years, or when we have a different presidential regime, things will not be different. You need to be very clear that when you're choosing a trustee, they can also see certain things. Previously, people were running to buy land parcels in Jodok or in Namanga, or people who are buying land parcels in places they have never seen. But today, you're able to buy land in the air, which is what we call apartments. You're able to buy real estate in terms of built environment. You're able to buy into an actual community of villas and, holiday homes and ocean beachfront apartments, which is where the country is moving into. You need a trustee who can see the value of what you've collected today and the value of what is going to be there tomorrow, so that it doesn't deprive your beneficiaries of what it is you're saying is generational wealth. So choosing trustees is important. And we've covered basically the world of estate planning. We've talked about what key features you need as a person, as an individual. How have you started? What are the strategies you need to employ? What are the issues that can come about depending on the circumstances that you have in life? And also, what are the tools that you can use? Okay, so preserving wealth across generations doesn't just mean it starts with you. It could start with your parents. You could even pull your grandparents. I actually have a family that pulled in their grandparents because they owned the house that their parents lived in. And now one of the sons was living in this house. So you can see it already is 2 generations back and nobody has transferred this asset. If anyone within this line kicks the bucket, it will mean that everyone has to go to court to prove that trail of ownership. If you find that one stray hair is all it takes to make sure the succession cause goes on for years and years and years. And believe me, intermeddling, which is what we call dealing with someone's property after their death and it has not gone through the court process, is a crime. So you'd be perpetuating a crime because you're using someone's assets, yet they have not been determined to be owned by you. And someone could actually just make your life a living hell because of that. So you need to be very wise in making sure that my plan is constantly evolving with me, evolving with the times. Remember, things of value 30 years ago are not going to be things of value 30 years from today, and that my beneficiaries understand why I'm making this plan. And my beneficiaries, again, are anyone who might be dependent on me in any kind of way, through love or through money. They are dependent on me. So I need to make a very clear plan and make sure that this plan adopts my life circumstances as I go along. Not that my divorced spouse from 15 years ago is now the beneficiary of my life insurance policy because I did not change it. So yes, the conversation starts with saving and creating emergency funds and creating trust funds, but it also means that those trust funds have to have a place they rest. Those emergency funds have to have beneficiaries they can go into and not leaving it to the courts and the people you leave behind to decide. So that's it for my presentation. Thank you very much, Mnindo and Susan, for giving me this opportunity. We will take as many questions as Susan guides us into. But before I close, I want to show you the sample will that I was talking about. Allow me to just show you that so that you don't say, Winnie promised us this. Just a moment. Yeah, here it is. So you can see it. Can you see my screen?
Yeah, we can see, but we're still seeing the.
You're still seeing the presentation. Let me stop
Yeah.
sharing and add the wheel. Okay, you can see it.
Yes, now we can see.
And I mean, please, your wheel can be 1 page or 10 pages. Depends. Okay, this I'm going to say depends. Your wheel can be anything as long as you want to put it down in your will. And forgive the legalese in this. Usually we say agreements and documents are set for the best of times. The worst of times depend on the thinking of that person in his best of times. So if he imagined the risk and challenges at that time, then he'll have countered it in this moment. So when we are writing a will, we make sure that we put your name, we say who you are by your identity card, because we have an ID. Everybody has one unique ID. And then we say where you live or give your postal address if that's something that's attached to you. Then we appoint your executors, and the executors are the people who will be taking this will to court. They'll be the ones taking the will to court. And remember, they'll go to court, be opened, be given permission to now read the will to the family and do what is supposed to be done as per your will instructions. You'll then appoint guardians. Obviously, it will be the same as appointing executors. You'll give their names, their identities, and how they can be contacted. And here's where it gets a little bit tricky for people: specific and pecuniary legacies. And why we put it like that, or why I put it like that in our will, is because by law, this define financial owned things, liquid and accounts. Okay, so it could be cash under your mattress, it could be a bank account, an M-Pesa account, an M-Shwari account, a till, a pay bill, a digital account, a chums, whatever you want to say you own. We put it under pecuniary legacy because it's unique and financial, and it is identified by a number. Okay, so this also calls for the things that you own in your house, those things that you can cover for fire and theft. Those are pecuniary to you. They cannot really be set aside and say, this was Susan's phone. No, Susan owned a black Samsung S24. She can just name it as her mobile phone. If she changes it in 2 years, it's still her mobile phone. She can change her laptop any day. If she can change her furniture any day. So you need to be clear that you've set aside these things and you've written them down. You write down your bank account, where it comes from, and here is how you put them down. Where your bank account comes from, the SWIFT code, the branch number, if it's a US account number, how your life policy is structured, the real estate, you name it by the land title number. Of course, your motor vehicles and other things are labeled by their logbook number, but you can will away your motor vehicle today and then you change it next year. So with that, it makes your will constantly get updated. So you can do specific legacies. Other specific legacies are now life insurance, pension policies, something that can be identified, has a nomination form, has someone you can even reach out to. Maybe you can give them contact information, and then you give instructions. You say, I instruct them to make sure the accounts can pay my expenses. Maybe it's hospital expenses, or you had a creditor, maybe you left a bill that hasn't been paid. The executors can do that. You can instruct them how to open an account for either a trust or for your family, and then transfer the funds that you have in your bond account. Again, the list is endless on the kind of instructions you can give them. You can even instruct them on how to invest, how to create a trust. You can create a trust and put it in your will and say, this is a trust to be used when I pass away. And then you tell them that, you know what, everything you do, as long as you've done it in good faith, no one should sue you. My family is not allowed to pass on that liability to you as a person. You're just executing your job as you should have. Because remember, you're appointing people who are probably related to you, are your friends, are people who are doing it out of the benevolence of their life and their love for you. So it's simply a job, almost kazi ya kanisa, okay? Then you sign it in the presence of two people. Remember, two people must witness you signing it, and you just say what it is that you own, identify it specifically, attach copies if you want, okay? And if you want to extrapolate your instructions or exaggerate whatever kind of things that you need, you can talk to me, yeah? So that it's also clear that you've indicated exactly what you need in your will, and that when you're updating it, you're simply updating it for, I sold this land, I am buying another one, or something like that. And when you're updating, you'll be creating what we call a codicil being an addition to your will. It's just adding to what you own, okay? And I hope you could see that the whole document in itself. So yeah, that was it from me. Questions, over to you, Sue.
Winnie, we
Yes.
are on fire here in the comment section.
Gosh,
The
goodness.
most
Oh my
pertinent
goodness.
question, yeah, the most pertinent question.
Yeah.
This one I know we hadn't discussed this, so you can just let us, you can guide us on how people can access this template. Do
Mm.
you mind sharing it via email, or should people just reach out to you personally, the people who want it, to get it? So I've actually gotten quite a number of direct DM, like private DMs, but I've seen
Mhm.
a number of people have already also shared on the comment section. They're
Okay.
saying that if they just had a template, they would
They would write
they'd
their
have
wills.
been able to write
Okay.
their will. So I don't know, what do we
Okay.
do about
Okay.
that?
Well, you can reach out to Nyindo. There's information that she can get from you, so that we see also whether you can get this as a template, or do you need further advice, because you can get a template and then you don't know how to work it. Okay, so
Yeah.
I'm not saying no, I'm also not saying it depends, I'm just saying reach out, then you'll get further advice on how to get the will structured for you. It is not expensive. Again,
In
lawyers
fact,
are not
I was heading
expensive.
there. I was heading there because I've gotten
It
two
is
people
not
also,
expensive.
yeah, ask the
Yeah.
will.
It's not expensive. I think the highest we've done is probably 35 to 50K. Depends on the amount of advice that you need, and how much structuring you need in a will. Some wills are a bit complex. Some are joint wills because they're doing it as a couple for joint property, or they're doing it as people who invested together. And some wills are also trying to undo what you already own. So in the process of writing your will, I know I said you can write your will about anything and everything under the sun, but as you're writing your will, you need to be very clear the effect it's going to give. If you say my bank account needs to be closed, you need to be very clear that this is not the bank account attached to a mortgage. You need to be very clear in how you're writing a will, okay? So just reach out to Mnindo, then we can advise.
Okay. Someone is also asking, you've said that for this will to be in effect, we need at least two witnesses that are not beneficiaries in the will. So
Mhm.
Elizabeth Kamau in the comment section is asking, do those two people have to know what I'm writing in there? Like,
No,
do
not
they
at
have
all.
to? Uh-huh.
No, 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 not at all. They don't even need to read the will. They are witnessing your signature and you. They're witnessing that, there are people who write wills and then we pull in the person walking. As long as they have their ID and, they can be identified later on, no, you don't need to know what I've written. You don't need to know who gets what. You just need to know that this is my signature. I have written a will and you're signing that it is me who's signing.
Okay, that's really encouraging because some of us don't want anyone knowing our business.
Mm-hmm.
Um, so now the other question is about the whole concept of wills being challenged. Yeah. Again, as you've said, family can get complicated, spouses can get complicated, and wills can be challenged. So someone is asking, how do you prevent that scenario, that situation from happening, where like someone can come and say, Winnie was not in her right mind when she was writing this, she was under coercion, or she was not sane, or for, whatever reason they challenge, or we do not think it is a legitimate will. I think there's a time you even told me people fake wills and death certificates the same way they fake IDs. So how do we actually ensure that whatever my wishes are ironclad in the will?
Okay, that's a good question. Wills can be challenged, yes, because it's your statement. Okay. If today I came and told you I'm wearing gray and you challenge me and say, no, it's black, that's a challenge. Okay. So whatever I write in my will, just know it is open to challenge for as long as you have human beings on earth. The reason for it to be challenged is where now the real work comes in. Are you challenging my capacity as a person in writing that will? Yeah, that I was being forced, that I was under undue influence, I was not in my right mind, I was not. The reason for those two witnesses, though they should be live and knowing that you're writing a will, is for that purpose. They will be called upon to be asked. We see that you signed and witnessed that this person was writing the will. Were they okay? Were they mentally challenged? No. Were they under any kind of alcoholic influence? No. Were they under force? Was someone seated there holding a gun to their head, even if it's just an imaginary gun to their head? No. Did they write this will knowing they were writing a will? Yes. That's the role of that witness. Beyond there, the challenge is, oh, they didn't give me enough. They didn't give me what was belonging to me. Oh, they gave out the house I am living in. Oh, they gave out the car and yet I'm the one driving it. You see, those are different challenges. My son could feel more entitled to my house in Gong than my house in Nakuru. But I've given him the house in Nakuru because of my personal reasons. They can't now come and unalive me to make sure that they can't come and now make me come alive to make sure I say the same thing. They can only rely on what I placed as a statement in the will. So that gives the court a job to determine, was this the right thing to have done? Was it that they were doing it out of malice? Or are they trying to disinherit the child? Now that is where the contestation comes in. And they will close out your estate to determine whether that challenge stands. Are they saying that they were not properly given, adequately compensated, adequately inherited? What are they saying? That's the question. That's the role you're giving the court.
All right. Now this question here, I think it's so important to address. She says that my mother passed on without writing a will, and she's asking whether they as a family at this point now can create a family trust fund to manage her assets so that they can become either benefactors, enforcers, whatever, or do they first have to go through succession?
They can't avoid succession at this point. Yeah, unfortunately. When a person has already passed away and there was no plan in place, succession is the only route. Okay, because you won't access any of their properties without a court order. The lands office will need the judge's signature to confirm that this title can be transferred to you. The bank will need the court signature. Everybody will need to see that you went to court and did it the proper way so that they can now give you access or transfer the title to you. If she had no plan and now you have to go through succession, it doesn't mean that you cannot bundle yourselves up and say, instead of distributing 4 ways, 5 ways, 3 ways, however many number of siblings you are, you can put yourselves in a trust and say, let it benefit us through this trust. And this trust will also be for us and any children that we have within this family. Okay, that kind of protects inheritance from other disputes that may involve the siblings. I could be inheriting my father's property, and the day the title is transferred to me is the day the creditor comes to attach it. Or the day that I'm getting divorced is the day my inheritance is being split into two because it forms part of our matrimonial property. So it's very important to understand who receives under succession. Yes, they didn't have a plan, but as a group, they can create that plan and say, let's put ourselves in a trust. Let's create this umbrella that will receive everything that is coming from mom. Yeah.
All right. There's also another question. Does the enforcer have to be a legal practitioner?
Mm. Doesn't
So it,
no. The enforcer doesn't have to be anybody. Doesn't have to be a legal practice. Doesn't have to be not anybody, like professionally qualified person.
mm,
Yes, it's good if they are professionally qualified because then they'll understand their role, yeah, and they don't
mm,
need to constantly be, beckoned to perform it. But if they are not a professional, then you as a person creating that role within your trust need to be very clear that you're explaining what they're supposed to be doing, why they're even put there in the first place, why you've considered them. Because there are people who come and ask, why am I the guardian of your child? Me, I can't live with this person. Why am I the enforcer? I can't force the trustees to do anything. So you have to be very clear that you've selected someone. Are they charging you? If they're professional, there are maybe a bank advisor or Coach Susan is your enforcer. She'll charge you or she'll charge your estate to make sure that she's participating in your estate. Because again, remember, this might be their professional responsibility to you. But if you're choosing an individual out of purely voluntary basis, they also need to be very clear why they've been selected and the role they've been selected for.
okay. Now, assuming I've done a will already, and of course, in the course of life, things happen. I can acquire new assets. I can divorce my wife, and I want, maybe said they will get the house, and now I'm like, no, don't give her anything. What is the process of changing, updating? And in case you're using the same lawyer or the same legal firm, do you incur additional costs to keep updating or changing what you had included in your initial will? What does that process look like?
Okay. So if you've gone to your lawyers and they've helped you write your will, they might charge you to add or update your will because probably you're updating your will 3 or 4 years from the day you created it. But for me, my rule is usually as long as you're doing it within the first 5 years, we'll keep doing it as long as also the revisions and the updates are not more than 5 within those 5 years, because then that means you're just coming for free legal counsel, which is our bread and butter. So I'd say yes and no, depends on what you're trying to do. If you're simply updating or revising or adding into the will genuinely, then I wouldn't see why you should be charged. But if they do charge you, they're probably charging you for the time and care they're taking.
Okay. Another one. If a will is rightly executed, let's assume everything has been followed to the T and no disputes and all that. Once the owner of the estate dies, the person is asking, can the distribution happen immediately? And I think this is a timelines question, or are there court procedures to be followed? This is working with an assumption that the will was rightly executed.
Okay. A will rightly executed, meaning rightly signed, like, or the executors have done the right job.
They've just written that. So I'm
Mm,
thinking the assumption here is, okay, let's assume I wrote a will.
mm,
And I'm now dead. What is the procedure now?
mm,
I
mhm,
guess for the
mm.
distribution to happen. I guess the question is the distribution just going to happen immediately? Like we've read Mom's will. Mom's will said I should get the Ngong house. How soon can I move in?
Okay. Yeah, well, it takes time. Obviously, it takes a much shorter time than the succession because your will, as it is, must be sealed. Okay. So I'm assuming nobody has read your will. They don't know. So the person executing the will, as you should rightly have told them that they're executors of your will take it to court, have it opened in court, and then all the instructions can be read. When the instructions are read and the family has been made aware, that's when now you'll start the process of collecting the titles, and they'll be given, what the executors will be given is a grant of probate with will annexed to be able to now transfer the properties to you. So I wouldn't say it takes a year, but it takes maybe 6 months or less to conclude the process of transferring properties to the rightful distribution, heirs.
All right.
Mm,
Someone has also asked, my father gave his title deed of a very
mm,
big piece of land to his brother for safekeeping. Okay. He also wrote something on paper as his dying wish, but it did not really state how things should be shared. It only said that the farm should not be sold as long as my mother is alive. So from the question, pretty much the uncles have the title deed, okay? And the father did not say how it should be distributed. However, he said that the piece of land cannot be sold as long as the mother is alive. So the question is, do my uncles have rights over the land as they have refused to give back the title deed to my mother, who's the only surviving spouse? So the question is, how can this issue be tackled? Does she actually stand to lose out?
Well, that's an interesting
And maybe
question.
let me pause you.
Mm-hmm.
Maybe as you answer that, there's I think the same question from someone else
Mm-hmm.
saying that the grandfather passed without a will. He was also polygamous, and of course now there's quite a number of interests to his property. So I guess both issues are speaking to there's a property, there's whatever there is, and no clear instructions, and there's people who have vested interests. How should these people proceed to get the, especially like now for the surviving spouse, for example, for the grandchildren of this grandfather, how can you go about this legally to ensure you get the property or the whatever it is that was left?
Wow. Wow. Okay. The father gave the title to his brother, but did not give the land.
Yeah,
Like that's
he gave the title for safekeeping.
safe.
Weshikilia
So
title deed uweke
no.
vizuri.
So it's in your
Mm.
it's in the father's name.
Yes.
So where do the brothers come in? What rights are they gathering? Because they have gathered I'm assuming they have gathered rights because they hold the title document, quote unquote, but they have no rights on that land. The property rightfully belongs to the spouse and her children for so long as she has children, and she doesn't even need the original title to go to court and have a court order for the brother to release that title to her. No other brother has a right to that property. I would say, that's a very
Mm.
simplistic view of the issues surrounding that matter. But she can go to court. She should have gone to court by now to do succession because she's the rightful administrator, number one. Two, she should have her children enjoined with her in that succession matter. And three, she should get the court to demand that the brother releases that title so that they
Mm.
can rightfully succeed their father. It's not a question of, oh, he gave us for safekeeping and whatnot. Uh, I can give my title to a bank and then I pass away. Does that title belong to the bank? No.
Absolutely not.
Yeah.
Yeah.
So the other question for polygamy, uh, polygamy is a very sensitive issue. One,
Mm.
because sometimes polygamous situations arise where one of the spouses in this relationship did not know that they were now being brought into a polygamous situation. And even if they knew and became complicit to it, they were not fully they were not fully complying to the idea of sharing rights. So
Mm.
it's the emotions that they're battling that they're not able to give themselves equally. Okay. And equal becomes subjective in that regard. So I feel like I should have been given this as opposed to what you have been given, and simply out of spite or just out of resentment. And that becomes a court battle for years and years. I can just hold on to that idea forever and ever. And I'll keep telling my children, we're being robbed. It is us who are supposed to get the house on the corner, not them. And them, they are supposed to get the house near the river. It's usually a very emotional conversation that has been brought in for legal battle. And the court will force you to decide. So if you cannot bring yourselves together for mediation over that issue, then you'll forever be in battle.
Yeah. Let me ask you, does this also apply to an illegitimate child who is seeking provision from their father's estate? So the father passed on, and he did not include this illegitimate child in the will. So the person is asking, as much as the illegitimate child had not been included in the will, do they have any legal grounds, assuming they are the actual child as per birth certificate, DNA, whatever, can they seek provision from their father's estate even though the father had a will and had not included them?
Yes. Every
Okay.
child has a right to inherit. It's a
Mm,
constitutional right. So
mm,
whether or not you participated in raising me, I have a right to inherit from you. And
mm,
that's where the concept of illegitimacy comes in, because people
mm.
try first to prove the legitimacy. And once they've proven the legitimacy, you're only legitimate until we confirm you are an actual child. Then you
Yeah.
become a legitimated child, and then you become a child. So you must be provided for. And for you to disinherit this child, you must state clearly why you're disinheriting this child. Either you didn't know of them, you have no reason to provide for them, or
Mm.
you've adequately provided for them in their lifetime. You have to have a very good reason to disinherit your child, one, and then to disinherit an illegitimate child. But if you left it open, then the court will pull up that child as
So yeah.
as a rightful heir. Yeah, you'll
Okay.
be
Okay,
pulled up
that's
rank.
great.
Mm.
One last question. Is there such a thing as joint wills between husbands and wives? Like, can your spouse and yourself write a joint will, maybe pros and cons of individual wills and joint wills, as we prepare to wrap up?
Okay, joint wills, and I dare say they're usually for jointly owned assets. So I
Mm,
own the title number A with Susan and Mnyindo. So
mm.
now me, Susan, and Mnyindo have to write a will to declare this asset will go in a particular way. Okay, so you're giving instructions, because joint property usually naturally says I own it and Susan owns it and we both own it together 100%. So if I pass away, Susan owns it 100%. Or if Susan passes away, I own it 100%. But in our joint will, we're going to say, because I own it and I know it's legally going to flow to you 100%, I would like that you hold it for so and so that when you pass away, it becomes for this person or for this purpose, so that the instruction does not fall away just because there's a joint ownership. Does that make sense? So we jointly say
Totally.
this instruction.
Okay, okay.
Yeah.
So if you're a husband and a spouse, but you have assets that are not jointly owned, it would probably be better to
Write
um,
individual wills.
write individual
Yeah.
will. All right. Thank you so much, Winnie. Mnindo, you can join us back. I'm just gonna turn my camera back on so that we can
Good to see
also
you.
have Mnindo joining us. Guys, please let us know what your takeaway, the key takeaway points are for you. We've dropped a link right now in the chat box for anyone who would like a discovery session. Obviously, some of these legal issues are very individual, they're specific. If you'd like a discovery session with our advocate, Winnie, please use the forms. And also for all the forms that we've actually sent in the comment section, we are going to be sending them over on email as well.